So I think now the question to the all of the panelists, which forms the overarching theme of this conversation, which is when we talk about conflicting, because Irfan Saab talked about conflicting decisions and, to quote him, the havoc that they've wreaked, and which is true, which is true in the Pakistani context, more certainly, as you said. But the idea, and the idea that consistency is is an imperative in itself, is an end in itself. The judges should always be consistent, and we can talk about sort of in different contexts. We have these debates in the U.S. on reading the Constitution and on originalism and textualism, and I think that needs to be interrogated.
Now, just for an example, I am telling you that Sri Lankan Supreme Court is acting fearlessly at the moment. Once it was decided that the government formed by His Excellency the President was illegal, and that government was dissolved, and then the Supreme Court makes certain decisions against the former Prime Minister, the former President, then the IGP and all regarding the Easter Sunday attack, saying that they are liable and they were ordered to pay compensation, and I was on that page too. So the Supreme Court fearlessly going into it, but what is the limit? So that is one area.
Inconsistency, what is healthy inconsistency, or which brings stability and which not. And I can begin by the Sri Lankan experience. We were judge of the Sri Lankan, former judge of the Sri Lankan Supreme Court, and I can put the question to you: what's the Sri Lankan experience been? Can you hear me? You can talk. We can do this while sitting down as well, if you want. I mean,
Now, before going into that unnecessary, I think that the one part of this topic that eroding the rule of law is one aspect that we have to discuss. If this conflict of judgments is because of the eroding of the law, rule of law, then it becomes very serious. I'm talking from my experience in my country. You see, one issue that the judges are facing in our country at the moment is that the criticism of the judgments of the Supreme Court judges. As His Lordship the Chief Justice said in the morning, the judges have to be prepared for the criticism. I totally agree with that. I totally agree with that. But if it is a constructive criticism, yes, judges will have to accept it and they will have to get themselves corrected if there is anything wrong. But if it is a malicious criticism, what is the situation? Now this comes especially when the criticism is done by a politician in parliament. Now we have some experiences where the parliament is discussing about the Supreme Court judgments. So they are doing this under the parliamentary privileges. So whatever they say, the judges cannot take any action. So then what happened is, if the judges are not prepared to face that criticism, then they will try to make the judgment more softer. That is one area.
Sir, there seems to be a problem with the microphone, and maybe you can come on the rostrum, or you can have a
What I say is, the reason for the conflict of judgments is the matter that we have to discuss. Now, in my country, we have some experience that the judgments of the Supreme Court is criticized by the parliamentarians in the parliament under the privileges of parliament. So once it is done under the privileges of parliament, the court cannot question them because it is their privilege. But then when it happens in that way, what happened to the judges? They don't want to face that unnecessary criticism. They can't take action, they can't answer. So then the following judges may take a different view because of this situation, which has to be prevented. The other thing, when there are criticisms of that nature, the general public will not have, they will not trust the judiciary, or they may not go before the judiciary to get relief, because the judges' decisions are being questioned in the parliament. So this type of situation can create lot of this can lead to lot of conflict of judgments. That is one area. And as your lordship said in the morning, if the judiciary is weakened, all the other institutes will be weakened, because the politicians or the people in authority will take action, they will be able to take action against those institutes who are working according to law. So under these circumstances, what I say is that we as judges and you as lawyers and the general public must take an initiative to protect the authority of the judges. Once the authority is protected, they will act fearlessly, and then this problem can be solved. Now, just for an example, I am telling you that Sri Lankan Supreme Court is acting fearlessly at the moment. Once it was decided that the government formed by His Excellency the President was illegal, and that government was dissolved, and then the Supreme Court makes certain decisions against the former Prime Minister, the former President, then the IGP and all, regarding the Easter Sunday attack, saying that they are liable and they were ordered to pay compensation, and I was on that page too. So the Supreme Court fearlessly going into it, but what is the limit? So that is one area that I want to bring to your notice, and I think we should discuss on that also. How long can I take? Yeah. Yeah. The other, this eroding of law is happening in another way also. Now, in Sri Lanka, we can't have a review on enacted laws. All the review is at the bill status before enacting it. So in recently there was a act presented for the online safety, and I am the chairman of the Human Rights Commission, and we were very unhappy about it, and we expressed our opinion on that, and the parties filed action in the Supreme Court. The Supreme Court gave a determination saying that certain sections to be amended, but once the act is passed, we found that several sections have not been amended and it is enacted as per the bill, and we found that it is not in line with the Supreme Court determination. Then we had to write to the Honorable Minister and the Speaker, and that situation is there. So then what happens? Now the Supreme Court determination was to amend it, but the Parliament did not amend it. So the authority is there with the Supreme Court to say that whether this cannot be passed or not. When the Supreme Court says that this can be passed only with two-third majority, the Parliament passed it with half simple majority. Then in such a situation, how the Supreme Court judges will act, what will their feeling. Now all these things will come into this conflict of judgment. That is why I say that there may be so many reasons for this conflict of judgment. On the other hand, there may be reasons that the certain law had not been presented to the judges and they were ignorant of it. It's a normal thing. It can be rectified by a bigger panel. But these are issues I think we will have to address, and we will see. We'll go on with the discussion. And thank you.